Fraud. Let's talk about Fraud Act 2006, where the criminal offense of fraud is defined. There are three kinds of frauds. Fraud by false representation, fraud by failing to disclose information, and fraud by abuse of position. Fraud can be one of the questions in your criminal law exam, and that's why I would like you to understand what is fraud and how to argue a case, a problem, how to answer a problem question about fraud in a criminal law exam. From my experience, there is usually at least one problem question about fraud in a criminal law exam. So, Fraud Act 2006, Section 1, 2, 3, and 4. Section 1 just says that points to Section 2, 3, and 4, and it says that this section should be referred to for different kinds of frauds that are set out in this statute. Fraud by false representation. Section 2. These are the things that you need to prove to get a first class on a fraud problem question. First of all, you should show that the party you're advising in the problem question has been or not dishonest. So dishonesty test should be applied. False representation to make a gain or cause a loss to another. So you should show that the problem question facts that they've given to you shows a false representation to make a gain or cause a loss. False is also defined in the statute as misleading and untrue. The person making representation must know that the statement is or might be untrue or misleading. Opinions cannot be fraud. So it must be a statement that was made knowingly, and the author of the statement knew or should have known that it was not true and it was misleading. As for any criminal law offense, you need to talk about actus reus and mens rea. Actus reus is physical element of crime. So you need to say what is the actus reus and then apply that to the facts of the case, of the problem question that you're answering. Actus reus of fraud is false representation. Representation must be false or misleading. So you should show in your answer why you think that this particular representation is false or misleading. Make arguments. And you should also show the defendant knew that this representation, the statement he or she was making, was false or untrue. They will give you some facts that you need to pick up on and make arguments. The representation must be a fact or law or a state of mind. It cannot be an opinion. So you need to discuss what kind of representation was made, and you need to conclude whether or not it was one of the fact, of law, or a state of mind. And you need to show that it was not an opinion. The matters of opinion must be treated as representations of defendant's belief as to the facts. Also, you should show whether or not the opinion was honestly held. Remember that fraud is all about dishonesty, and dishonesty should be proven. If the person was not dishonest, then the fraud by false representation cannot be proven. Mens rea of fraud by false representation. After actus reus, which is the physical element of the crime, you should discuss the mens rea, which is the mental element of crime. First of all, defendant knew the representation was or might be false. First, you need to define what is mens rea, and then you need to refer to the facts of the case from the problem question and say if why or why not the defendant knew in this case that the representation was false. Show that defendant was dishonest. Show that defendant intended to make a gain or cause a loss. Those three requirements are extremely important for a problem question on fraud. Dishonesty test. there was a different dishonesty test, but it was changed a few years ago. So you should cite the relevant case, which is IV. And 2 questions must be asked. First of all, what was the actual state of defendant's knowledge or belief? Fraud is about dishonesty, is about lying. And so you have to show that the defendant's knowledge was that he was lying, that he was making a statement that was supposed to make a gain or cause a loss dishonestly. And secondly, in the context of question 1, was defendant's conduct dishonest by the standards of ordinary decent people? You need to make arguments like based on the facts of the case that you've been given in the problem question. To what extent was the statement dishonest by standards of ordinary decent people? Fraud by wrongfully failing to disclose information. This is section 3. Before we were talking about section 2. So about section 3, this is a bit different. But what you need to prove here is similar. Dishonesty should be proved for all kinds of fraud. Doesn't matter if it's section 2, 3, or 3. Dishonesty applies. So always explain what is the dishonesty test under IV and apply it to the facts of the case. Failing to disclose information when they were under a legal duty to disclose. So if the defendant was, because of his position, under legal duty to disclose something and he dishonestly has hidden that fact, that can be fraud by wrongfully failing to disclose information under Section 3 of the Fraud Act. Again, for the purposes of making a gain or causing loss. Fraud by abuse of position. This is another type of fraud that is covered, set out in Fraud Act 2006. Occupying a position in which they are expected to safeguard the financial interests of another. Dishonesty, intention to abuse their position and make a gain or cause a loss. So dishonesty and make a gain or cause a loss is a requirement for all kinds of fraud. Doesn't matter if it's section 2, 3, or 4. It's a requirement for all kinds of fraud. But the rest of the requirements differs for each kind of fraud. Now, for this one, fraud by abusive position, there must be a specific position that the defendant holds, and he was supposed to safeguard financial interests of another. For example, company directors have fiduciary duties, and that means that they have to safeguard, they have to always act in the best interest of the company, serve the shareholders, and take into consideration the financial interests of the shareholders. So in that case, if they make a dishonest decision that was for the purposes of defrauding the shareholders, that can be fraud by abuse of position. Here is a case that you could have a look and cite as well in your problem question when you're discussing fraud. 2 gangmasters who controlled a group of farm workers deducted pay to force workers into debt. And the issue was if fraud was established in this case. It was held that the court held that the defendants were liable for fraud by abuse of positions because in the position that they were in this case, it allowed them to force people to take debt. So that's why it was fraud by abuse of position. They did not fail to disclose information. They did not make false representations. They just abused their position to make a gain or cause a loss to another. So that's why it was fraud by abuse of position. When you answer a problem question, make sure that you cite not only the relevant statute and the section, but also relevant cases. But it doesn't mean that you want to cite like all the cases that you've had about fraud. No, you should cite just the relevant ones and the ones that actually add value to the arguments. As a future lawyer and a law student now, Your goal here is to make high quality arguments, and you should cite the cases to back up your arguments. Don't just throw cases in there. Many law students do that. It does not help. It has to be adding value to your arguments. So here is an outline of how you're going to answer a problem question about fraud. And these skills are transferable. So this is like similar structure applies to all kinds of criminal law problem questions. You always need to discuss actus reus and mens rea and defenses. This is the same for all kinds of criminal law problem questions. First, analyze what kind of fraud you're dealing with. Is it section 2, section 3, section 4? Most likely there won't be just one which is relevant, but there could be multiple sections that come into play and you need to discuss multiple of them. Secondly, define what is actus reus of the relevant fraud. If you're dealing with fraud by false representation, then define what is actus reus of that specific fraud. Then apply it to the facts of the case and analyze if the actus reus is satisfied. This is true for all kinds of criminal law problem question, whether you are talking about murder, manslaughter, whatever it is. You need to discuss the actus reus. You need to apply the facts of the case, of the problem question, to the actus reus, and you need to analyze if actus reus is satisfied. Then define what is mens rea. Every crime has an actus reus and mens rea, except strict liability offenses that does not have mens rea. So after defining what is mens rea, then you need to apply the facts to mens rea and analyze if mens rea is satisfied. Finally, for fraud, you need to also discuss the dishonesty test, which is part of mens rea, and mention if any of the defenses apply. Defenses, like full defenses, for example, this applies to all the crimes, like insanity, automatism, duress. But for the purposes of fraud, it's very unlikely that any of these defenses would apply. Maybe duress, maybe. And just for you to know this formula, actus reus plus mens rea minus defenses equals to conviction. So if a defendant when a defendant goes to criminal court, the prosecution must establish that defendant satisfies the actus reus, mens rea, and there are no defenses. Only in that case, the defendant goes to jail. Duress. What is duress? Duress by threat. This is when defendant commits a crime due to threat by a person or someone else will be killed or seriously hurt. So if someone tells the defendant that if you don't do this, we're going to hurt you or someone else. Duress by circumstances. This is similar to the other one, just duress by threat. But in this case, defendant is not threatened by a person, but threatened by circumstances. Duress is a common law defense and it applies to all criminal law offenses, not just to fraud. And there is private and public defenses, which is self-defense, when somebody is acting to protect oneself, others, or property. Or public defense when someone is acting in prevention of crime or making arrests. These are applicable to all crimes. But for the purposes of fraud, I don't think any of this will be applicable, except duress maybe could be applicable. But you never know. You should know all defenses because you have to mention it in problem questions in criminal law. So make sure that you're familiar with all the defenses that I have listed here. For further information, please check out Criminal Law Study module on StudyCrowd AI. Thank you.